The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 913. And it is coming to you on Monday, the 10th of September, 2018. On this program, I will speak to you on the topic, the Caribbean Court of Justice, Part 4. I intend to do many more parts. But before getting into the topic, a few preliminary comments. Firstly, and as usual, I would like to send out deepest condolences to all families which have suffered recent bereavements. Secondly, I would like to applaud an initiative taken by Ms. Jabel Frank of NBC Radio, whereby last evening there was a program broadcast, or at least originating at NBC Radio, but carried on NICE and several other radio stations in St. Vincent and Grenadines, and I think one in Canada, one in the United States of America. And the program was called Light a Candle for SVG Prayer Vigil. There were 5 pastors, evangelists on the panel. They said prayers, and then the lines were opened and various callers called in and offered prayers for several aspects of national life. And a young child called in, and I found that child's prayers were so touching. I hope that a similar program can be aired in a not too distant future. And indeed, I hope we would be able to make that a standard feature of broadcasting, involving more stations, because you cannot have too many prayers being offered in a country, particularly one like St. Vincent and the Grenadines, which has been facing so many challenges way down the years. So congratulations, Ms. Frank, and a beautiful initiative, and the Lord will richly bless you for it. Final preliminary remark. We have been warned of the approach of Hurricane Isaac. Indeed, there are several storms and hurricanes in the region, 5 of them, I think, but Florence is heading apparently for the Carolinas and Virginia in the United States, and we wish the people in those areas all the very best. But the track of Isaac would appear to bring it smack into the northern Windward Islands and the southern Leeward Islands. Let me urge us all to pay heed to the various advisories which will be issued by NEMO from time to time. Let us follow the official advice we are given, and let us hope that there would not be a lot of damage to these islands which will be affected by Isaac. But it appears from what the meteorologists are saying that while it is not a strong hurricane in terms of the miles per hour of the winds, it is packing a lot of rain. And therefore, later this week, we in this country may be in for a lot of heavy rainfall and other disruptions. Let us take all the precautions which we have been taught to take at the approach of a hurricane. Okay, let me get into the program, the topic for the evening, the CCJ Part 4. As I promised last Monday, I would like to focus on this program on the vexed question as to whether a referendum will be needed in St. Vincent and the Grenadines in order for St. Vincent and the Grenadines to go into the appellate jurisdiction of the CCJ in place of the Privy Council. Let us take as our starting point the situation in St. Lucia. In 2005, the Parliament of St. Lucia passed an act whereby the Attorney General of St. Lucia could refer to the Court of Appeal of the Eastern Caribbean Supreme Court matters pertaining to the interpretation of the St. Lucia Constitution for an advisory opinion. Pursuant to that act having been passed, in 2012, the Attorney General of St. Lucia took to the Court of Appeal a question as to the interpretation of primarily 4 sections of the St. Vincent Constitution, aimed at advising the nation whether those sections made it mandatory for St. Lucia to have a referendum, among other things, before St. Lucia could become part of the appellate jurisdiction of the CCJ, or whether a referendum was not, strictly speaking, necessary. The Court of Appeal, by a majority, and that majority consisted of the Chief Justice, Justice Pereira, Justice Louise Blenman, and Justice Don Mitchell, Justice of Appeal Blenman and Justice of Appeal Mitchell. The 2 ladies agreed, but Mr. Justice Don Mitchell did not agree. Nevertheless, in our system, 2 judges out of 3 constitute a majority, and the majority judgment is every bit as binding as a unanimous judgment of the Court of Appeal. So, talk of the judgment wasn't unanimous and therefore it's just by the way. In cricket, you could win a test match by 1 run. It's still a victory. You could win a test match by 1 wicket. It's still a victory. The Court of Appeal in that case, and I have the case here with me. I can't, of course, can't read it to you, but it is suit number 18, of 2012 in the St. Lucia Court of Appeal. In the matter of the Attorney General's reference, Constitutional Questions Act, Chapter 17.18, and in the matter of the Attorney General referring to the court for hearing and consideration of important questions relating to sections 41.2, 41.7, 107, and 108 of the St. Lucia Constitution Order 1978. In a nutshell, the Eastern Caribbean Court of Appeal held or decided that once St. Lucia got a 2/3 majority vote in the Parliament, and once it got the approval of the British government, it could accede to the appellate jurisdiction of the Caribbean Court of Justice and get out of the Privy Council. In other words, the Court of Appeal ruled that in the case of St. Lucia, a referendum would not be necessary to accomplish that. Now, the relevant sections of the Constitution of St. Lucia are very similar, practically on all fours, with the corresponding sections of the St. Vincent and Grenadines Constitution. But you will recall that when this case arose for decision, or when the reference arose for a determination by the Court of Appeal, it was 2012, which was 3 years after our referendum here in St. Vincent and Grenadines, which took place in 2009. But interestingly enough, there was a strand of solid legal opinion on the question in the St. Vincent Constitution, which held that that section was not necessary, did not make a referendum necessary in the case of St. Vincent. But it remained a subject of debate because there had been no pronouncement on the question. So when the matter arose for pronouncement in 2012 in St. Lucia, and the Court of Appeal decided that St. Lucia did not need a referendum if it had a situation where there was a 2/3 majority of the elected members and the approval of the British government. Those who had, even before that, held the legal viewpoint that a referendum was not necessary in St. Vincent and Grenadines felt that their position had been vindicated. Excuse me. Now, there are 2 states in the OECS which are right now preparing to hold referenda or referendums. It isn't. The dictionaries tell us that the plural of referendum could be either referendums or referenda. Antigua and Barbuda, and Grenada, Carriacou, and Petit Martinique will be holding referendums later this year on the question as to whether those 2 territories should leave the Judicial Committee of the Privy Council and subscribe to the appellate jurisdiction of the CCJ. Because their constitutions are different in those salient respects than the St. Lucia Constitution or the St. Vincent and Grenadines Constitution. Some who are opposed to the CCG have voiced the opinion that notwithstanding the ruling of the Court of Appeal in the Attorney General of St. Lucia's reference, they say St. Vincent and Grenadines can't leave the Privy Council and go into the CCJ in its appellate jurisdiction unless we hold a separate and special referendum here in St. Vincent and Grenadines. Well, what the government of St. Vincent and Grenadines did earlier this year, the government went to Parliament with a law very similar to the law which was used in St. Lucia, passed in 2005. This law is called the Attorney General's Reference Constitutional Questions Act 2018, passed in our House of Assembly on the 24th of May 2018, received the Governor General's assent on the 4th of August 2018 as Act number 10 of 2018. And by this law, which became controversial as it was going through Parliament, the government of St. Vincent and Grenadines has empowered the Attorney General to raise certain matters before the Court of Appeal for its opinion, matters touching upon primarily the interpretation of the Constitution. Therefore, if the government is so inclined, notwithstanding the result in St. Lucia, if it is so inclined, it could go through the expense of holding a referendum on the question if it had the prior approval of 2/3 of the members of the House, because there are three fundamental requirements in, say, Antigua Barbuda and Grenada, Carriacou, Petit Martinique. One, you need a 2/3 majority in the House of Representatives. Two, you need a positive vote in that referendum of, in the case of one state, 2/3 majority in the referendum. The third requirement is the one that led the Court of Appeal in interpreting the St. Lucia Constitution to rule that once the approval of the British government was secured, and once there was a 2/3 majority vote among the elected representatives in the House of Representatives. Well, in St. Lucia, all members of the House of Representatives are elected. Well, they have a Senate, which is totally appointed. When you juxtapose the constitutions of St. Vincent and Grenadines on the one hand and the constitution of St. Lucia on the other hand, they are so similar in every material particular that the ruling in St. Lucia by the Court of Appeal is certainly, in my view and in the view of the vast majority of scholars and lawyers who are pronounced on the matter, that the ruling in St. Lucia is would have to be the same as the ruling for St. Vincent. Namely, what we would need in this country to be able to go into the CCJ is a 2/3 majority of the House of Assembly, the elected members, plus the approval of the British government. Now, there is no controversy about the prospects of approval by the British government. The British government has signaled that once a 2/3 majority vote is obtained in the House, the British government has said, look, we have no problem at all, we would approve. So that is not a controversial issue. Therefore, what is facing this country right now, and will continue to face it for the rest of the term of this government, is the issue of the size of the majority which it can command. Now, we all know that in the House of Assembly at present in St. Vincent and Grenadines, there are 15 elected members. We all know that the government side commands the support of 8 elected members, and the opposition commands the support of 7 elected members. Not the first time St. Vincent was having a government with a 1-seat majority. Because you remember the elections of 1998. In 1998, the election results were the New Democratic Party 8 seats and the Unity Labour Party 7 seats. Albeit that the Unity Labour Party got a much larger percentage of the popular vote in 98. So as of the moment, the government with 8 seats hasn't got a 2/3 majority by itself, because of the 15 seats elected in the House of Assembly, a 2/3 majority equals 10 seats. But the government hasn't got 10, it has 8. Therefore, unless the opposition voted with the government and supported the government, there is no chance of St. Vincent getting out of the Privy Council and going into the CCJ in its appellate jurisdiction. So what is in the offing is an attempt by the government to persuade the opposition to support it in the quest to go into the CCJ fully. Because we are already in the CCJ in its original jurisdiction. Let me repeat for those who may have lost the point. All CARICOM countries have subscribed to the original jurisdiction of the CCJ. That is mandated by the Treaty of Chaguaramas. So we all belong to the CCJ already. Once you're a CARICOM country, you have signed on to the CCJ as the original court to handle CARICOM disputes. But as we have been told from the time that CCJ was operational, the CCJ is really two courts. It's an original court for all CARICOM countries, but it is an appellate court for those countries who want to move from the Privy Council and bring their final appeals to the CCJ, of which there are 4 such countries: Guyana, Barbados, Belize, and Dominica. They are the only 4 CARICOM countries which have accepted the CCJ as their final courts to replace the Privy Council. And as I understand it, the government of St. Vincent and Grenadines is trying to get the support of the opposition in moving from the Privy Council to the appellate jurisdiction of the CCJ. St. Vincent's position has another peculiarity. We have contributed over 5 million EC dollars of the original funding of the CCJ. We have already spent that money, we've already put that money into the CCJ, $5 million. But we have never used the CCJ because no case has ever gone from St. Vincent to the CCJ in its original jurisdiction. In other words, there has never been any CARICOM dispute involving St. Vincent and Grenadines. So here we are, having paid over $5 million for a court. We have never used it. And as has been pointed out, to go into the CCJ in its appellate jurisdiction would not mean any further money from the taxpayers of St. Vincent and Grenadines. You see, the $100 million US trust fund, which was set up at the time the CCJ was formed, it was subscribed to by all the governments of CARICOM, and the rest of the fund was made up of a loan from the Caribbean Development Bank. Incidentally, the chairman of that $100 million US trust fund is of Ascension and has been so since 2009, Dr. Linton Lewis. So there's no question of the taxpayers having to bear any burden of the CCJ, albeit we do not similarly bear any burden as a government for the Privy Council. Where we bear the burden is when individuals in St. Vincent and Grenadines appeal to the Privy Council. A former Prime Minister said that it cost him $1.5 million to pursue his appeal before the Privy Council. And it has been demonstrated that the Privy Council is really for the well-off, unless you happen to be a convicted murderer when there are legal aid arrangements made for people with death penalty cases. But the opposition party has made it clear that it is not supporting the idea of moving from the Privy Council into the CCJ. That has been made abundantly clear. I have been waiting for the full reasons why that position has been taken. I have heard some complaints, but I do not regard the complaints I've heard so far as sufficiently sound reasons why we should keep this colonial court as our final appeal court, when the primary responsibility of a final appeal court is to mold and shape the society in a way that gives expression to the collective will of the people in that society, a role which the Privy Council, with respect, cannot play. Has been an excellent court in terms of expounding the law. But the Privy Council are simply not our people, they're not Caribbean people. And some of us hold very strongly to the view that your final appeal body should consist of your own people. It's a matter of sovereignty. I will deal with the question of sovereignty the next time I speak on the topic of the CCJ. So I hope it is a little clearer to you, but from time to time I will keep speaking on the topic because it means a lot to me, and I think it means a lot to the question of nationhood. Okay? So that is all from this program of the Law and You, program number 913. I look forward to being of further service to you next week, Monday, Divi, for another presentation in this public service nation building series, The Law and You. Do have a pleasant week, ladies and gentlemen, brothers and sisters, boys and girls. I hope the hurricane would not be too disruptive, but I hope we take our proper precautions. Until then, may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.